Ms. Rose.
So, my Lord, my Lady, we were dealing with the issue of proportionality as opposed to affordability.
Yes.
And yes, before I continue, can I just tell the court that we've had some discussion about timing over the short adjournment, and where we have got to is that I will be on my feet till the end of today. Then we have the agreement of the EHRC that we can have 30 minutes of their 1 hour. So there'll be half an hour from Ms Monaghan tomorrow morning, which means we will still be on the same timetable overall. But just in case you're wondering why I'm still on my feet, 3:30.
Well, Ms Monaghan's very kind. It's the second time she's given
It is
some...
very kind. She's a team player, my lord. Consistent...
And it's very, yes, I should add, it's very kind of the ECHRC too.
Yeah.
Thank you.
Wonderful.
Yep.
So, my lord, we've been looking at the legal aid funding code and the cost-benefit analysis. And consistent with the point that we make about the lack of proportionality of these fees compared with smaller claims, the review shows that there has been a particularly large fall in the smaller types of claim, including the type A claims. So if we go back to the appendix, part 5, and it's in the MS numbering 1854, and in the internal numbering, that's 1600. And we have a table here which shows the relative percentage fall in type A and type B claims. And as you can see, the percentage change for both of the 2 years considered here is significantly larger fall in type A than type B claims. So in the first year, 69% type A, 61% type B. Second year, 72% type A, 64% type B.
Is that significant? I mean, it seems rather small.
Well, my lord, we've got a pretty large baseline here, 17,000 claims versus 22,000. So that's translating into an 8% difference in the fall. That would be statistically significant, my lord.
Yes, I see.
And what,
8 percentage points, I should say. Yeah. Percentage points being, of course, larger than percent.
I'm with you. No.
Yes. Sorry, Madam.
I don't want to anticipate, but are you going to be suggesting an explanation?
Yes, my lord. The explanation is that the type A claims tend to be the lower value claims. And so they are the claims, even though their fees are lower than the type B claims, because so many of the type A claims are such low value claims that may be only worth £200 or £300, £400. People don't just simply, it doesn't make sense to bring them. So the rational claimant won't bring many of the type A claims. And your lordships will recall the submissions I made a little earlier about the types of claims that we're looking at under type A and their value. And if we look at particular jurisdictions, if we go over the page, 1856 in the external numbering, 1602 internally, you can see the same effect if we look at individual types of claims. That the fall in claims for unpaid wages or breaches of the working time regulations is significantly greater than in relation to unfair dismissal and discrimination. It's the same point, but differently analysed. Now, the response of the government to this point can be seen if we go to page 1808.
Right.
That's page 1554 in the internal numbering. And this point was identified, if you go to paragraph 166 of the review,
Yep.
this point was identified by the Council of Employment Judges and Presidents of the Employment Tribunals we see that they say that they were concerned there'd been a greater fall in lower value claims, such as unpaid wages or unpaid annual leave, and claims which did not seek a financial remedy, such as entitlement to breaks. They argued this suggested that at least for some types of cases, the fees were disproportionate to what was at stake in the proceedings, and people were deciding they were not economically worthwhile. Now, we submit that's a very important piece of evidence coming from, again, a highly authoritative source, the Employment Tribunal judges themselves. And the government's response to this, they didn't respond to it at all in this part of the review. The only place where they address this point at all is in the summary section. It's at page 1786. 1532 on the internal numbering.
Yep.
Paragraphs 39 to 41, where they say that we don't agree that some types of claim below a certain financial value should not attract a fee. Now, in parenthesis, of course, you wouldn't have to say they don't attract any fee. You could simply have a scheme that provided for a fee more analogous to the sorts of levels that you look at see in the county court. And they say, we believe the requirement to pay a fee provides the right financial incentive for people to give serious consideration to the strength of the claim and alternative ways of resolving the dispute, such as ACAS's conciliation service. Now, in my submission, that's just a hopelessly inadequate response. It's not the right financial incentive, it's the wrong financial incentive. Because for claims of this type, which are the very types of claims the employment tribunals were set up to provide, they are now not rationally sustainable.
Well, the alternative view is that it's right. You could be right, but the fee has to be, as it were, proportionate.
Well, and my lord, that's a very important point. Because if what they're saying is, we wish to have a fee structure under which small claims below £1,000 or £800 or whatever it is are no longer rationally viable, then that, my lord, is a very serious interference with the right of access to justice, and particularly in the context of the employment tribunal system set up by primary legislation for a particular statutory purpose.
No, I understand that. The point I'm making is that it's perfectly... What I'm quarrelling with, in one sense, is paragraph 39 is perfectly defensible if the level of fee is proportionate. You would accept that, I do.
But, my lord, they don't suggest that it is proportionate.
Well, I know. But they are defending a fee. They're not defending the level.
That's true. And there's nowhere that they even grapple with the point that's made by the Employment Tribunal judges. And your lordship can see in the following paragraph that they address the point about claims that are not claims for compensation at all, like a claim for regular work breaks or written contract of employment. And they say a complication is that would require a separate fee structure. They don't address it any further, and then they just say, overall, we consider the current fee structure achieves the best balance between the original criteria while maintaining access to justice. Well, that's conclusory reasoning, which doesn't assist in why they think that. And this in a situation, I don't want to repeat myself, where they have the burden of proof to establish proportionality.
Understand.
Now, the third point is the size of the financial benefit that's recovered from the operation of the fees order. And our submission is that it is relatively small. Because so many claims are deterred, this scheme does not raise a very great deal of money. And the income from the scheme can be seen if we go to page 1851. It's 1597 on the internal numbering.
Thank you.
Now, it's table 5. There are some oddities with this table. As you can see, the first column says gross income. The second says income foregone via remission. And the next says net income. Now, just to be clear, the first column is not income at all. It is the sum of the actual income received from fees and the notional income that would have been received if where there was remission, there hadn't been remission. So that is not actually income at all. It is an entirely notional figure.
Understand.
The actual figure for income is the figure called net income. It's actually gross income. The next confusion about this is that, as you will see, the figures under net income, 4.5 million, 9 million and 8.5 million, do not add up to 27 million, even though they purport to. What appears to have been done is that the first of these is for only something approximating to half a financial year, because the fee scheme came into force in the summer. And what they appear to have done is, in fact, prorated up the income.
So that explains why none of the first three sets of columns add up to
Correct.
the total.
I infer that that's what they've done, although I couldn't find a place where they explained it. Maybe that it may be that it's in this document, I just haven't seen it. But so that's why the figures don't actually add up.
Well, there's a note that hints at that at 61. It doesn't deal with it, but that semi-explains
I think it would appear to be that that's what they've done. Now, the other thing is that they've assessed, we then see that the actual costs of the Employment Tribunal over each of these financial years, where it says net surplus deficit, and then fee recovery given as a percentage. Now, again, that is not, in fact, the percentage of fee recovery, because they've included the remitted fees there. That's the gross income as a percentage of the actual expenditure.
So if you take net income, which is the actual income.
What you get, my lord, is figures more like the following: 6%, 12.6%, 13%, and then an overall average of 9%.
Why is the remission figure so much higher than the evidence would suggest of fees which were not income not charged?
Because, my lord, this is talking about the whole of the remission scheme, not just exceptional cases remission. The 31 cases was the Regulation 16 remission.
I see. These aren't just regulations.
This is all of the remission.
Thank you.
So it could be in the exceptional category is after people are meant to have exhausted the remission scheme.
That's right.
Yeah.
That's right.
Yes,
So almost all of the income forgone via remission is under the scheme.
right.
So what we in fact have is that the fees are contributing a little under 10% on average of the costs of the Employment Tribunal. Now, what we then have is project expenditure. So these are the costs of the fee scheme. Now, these are included in the global figures for the tribunal costs in the preceding table. But what these figures tell us is that over this period, these 3 financial years, they spent 5.7 million on implementing the scheme. If you take the actual income, which is actually a little over 22 million, not 27 million, and you deduct from it the 5.7 million, the actual income from the fee scheme over this period is 16.374 million.
Well, I suppose they may have done the same exercise with Table 6 as they have with Table 5, but even then, your point's the same, isn't it?
Yes.
Yeah.
So that's a little over 16 million income net of the costs of implementing the scheme over a 3-year period, which is a bit over 5 million a year.
Do they say anywhere what these costs are?
Well, we can see that some of them were capital costs.
Yes, I can see that.
The
But I mean, what
yes.
have they spent it on?
My lord, I think we can give the details. I'll try and find the reference for your lordship.
What I'm getting at is whether it's one-off or whether it's
A significant
repeated
proportion
annually.
is one-off. The ongoing costs are in the region of 7.
Yes.
So about 700,000 a year.
Yeah.
Now, if we go to the conclusion, we go to page 1803 and the external numbering, see what they say about this. So this is their assessment of whether they've met the financial objective. It's 1548 to 1549 on the internal numbering. And they say at 1548, that's 1802,
Yep.
paragraph 134, that that the amount of income they're obtaining is within the range of what they'd anticipated. But then they explain at the bottom of the page that they had to invest in IT systems. There we can see some of the costs summarised, yes. And then at 140, they say this: our original impact assessment estimated that the introduction of fees would achieve a cost recovery rate of around a third, taking into account fee remissions. The actual recovery rate achieved has been much lower. 17% 2014 to 15, 19% 2015 to 16. The main reasons for the difference are a combination of two factors. First, the fall in the volume of claims was greater than we'd estimated, and the fall in type A claims has been greater than type B claims. And secondly, the value of fees remitted has been lower than we estimated. Now, the first of those is highly significant, because what they're saying is it's making a lower contribution to the costs of the employment tribunal system than we'd anticipated, because far fewer claims are being brought than we had anticipated.
Particularly in type A.
Yes, and then at 141...
I'm going still on 140.
Yes.
17%, 19%.
That's taking into account the notional
Taking
remissions.
into account fee remissions.
Yes.
What? Taking them out or adding them in?
That's assuming that was income, treating the remitted fees as
Yes,
if they
because
were.
that's they've collected that from
That's right.
Table 5.
That's right, my lord. But the actual figures are much lower for
Well,
actual.
quite.
It's actually about around 12, 13%.
Yes, quite. Thank you.
Well, what about their 1/3 was also supposed to be taking into account
Yes.
fee remissions.
That's
Have
right.
we seen that calculation?
That's in the impact assessment, my lord. Now, so if you
Can you give us a
compare,
reference? Yeah.
I can, my lord, but
Yes,
not,
at some point.
not off the top of my head. But so if you compare like with like,
Yeah, right.
they're making somewhere between 17 and 19 instead of 33%,
Yeah, right.
which is obviously a very significant shortfall.
Not much more than half.
Indeed, my lord.
Yeah.
And one of the main reasons for that is the significant fall in the number of claims. It's not just about lower levels of remission.
We've got that point.
And my lord, at 141, they then say our conclusion is the introduction of fees has broadly met the main financial objectives set, level of income broadly in line with estimates, transferring a proportion of the cost from taxpayer to users. The low cost recovery rate, which takes into account the value of fees remitted, has, however, been lower than we originally estimated. Now, with great respect, again, bearing in mind this is, as I've said before, a document prepared in the course of this litigation and the knowledge of this hearing, the data doesn't bear out the conclusion, because the data shows that it's not meeting their financial objective, and that one of the main reasons it's not meeting their financial objective is because the fall in the number of claims has been much greater than they expected it to be. And that should have immediately caused them to think about the Lasser curve. But they don't.
How can the level of income
Quite.
have been broadly
I know,
in
my
line
lord.
with estimates, bearing in mind?
I share your lordship's bafflement.
Yes.
And I have raised this question. Unfortunately, we don't have enough detail from the original impact assessment. The calculations are not transparent.
Yeah.
And we are unable to bottom out how that can be. It doesn't, I agree with your lordship, it doesn't add up. But we are where we are. Now, what these figures actually show is that the employment tribunal fees are inefficiently high. And I'm using here inefficiently in its economic sense.
Yes, yes.
They are inefficiently high because they're suppressing demand to such an extent that the fees are contributing less to the cost than was anticipated.
I wonder, in answer to the question just asked by Lord Mans, when they say in 141 that the level of income generated by fees has been broadly in line with estimates, they said in 134 that the impact assessment estimated the introduction of fees would generate fee income of around 8 to 10 million.
Yes.
The figures in Table 5 that you took us to a moment ago showed
Yes.
for the complete years 8.5 million in one year and just over 9 in another. So
Yes.
perhaps that's what to say.
Just at the lower end of the scale.
Yeah.
It's possible, my lord, but we just don't know enough about the way that the original figures were calculated to be able to answer that. But the point remains, and this is a point that the government have fundamentally misunderstood. And we submit this is fatal to their case on proportionality. So if we go to page 1833, It's 1579 internally,
Thank you.
paragraph 307.
Yep.
They say, we have considered whether it would be more proportionate to charge different lower fees for ET proceedings or to transfer some of the burden of fees to respondents. The result of reducing fees would reduce the income generated by fees and thereby reduce the proportion of cost transferred to users from the taxpayer. Well, there's just no basis for that statement. And, my Lord, we see the same error repeated by the respondent in their written case. If we just take up the core bundle, it's page MS 151.
Thank you. Paragraph.
It's paragraph 48.
Thank you.
I just invite the court to read paragraph 48. That paragraph is fallacious. And this misunderstanding is crucial because it's actually quite likely that a lower fee would more effectively meet the main financial objective.
Yeah, we understand.
And this is something that the government has wholly disregarded.
There's also a reference in 307 to charging a respondent a fee.
Yes.
I don't know whether you've got any submissions on that. Before I saw that, I was wondering over the weekend about, well, it takes two to make a dispute.
It does, my Lord.
Why mightn't there be a fee for putting in a defence, just as there's a fee for issuing a claim?
Well, indeed, my Lord. That might well be more proportionate, and particularly when you're looking at a statutory scheme where there is a fundamental inequality of bargaining power between the employee and the employer, and which is designed to enable the effective enforcement of employment rights. And also, of course, that would be consistent with the aim of promoting settlement, because it would give the employer...
Are there any proceedings you know of where a fee is charged to a defendant or respondent?
I'm being told that there are some places in Scotland that do, but I don't want to be drawn on that, my Lord, because I don't know any of the details.
I know of none.
But in any event, my point is my main point is the more basic one.
Yeah, quite.
Yes.
And they do consider the response.
And the key point is that in the face of this evidence, there has been no attempt to model what would be the financial implications of a lower or better targeted fee. And they cannot, we say, establish proportionality in the absence of that. Now, the next point is that the success rate has not improved. On the contrary, the evidence shows that it has worsened to some extent. Now, the government don't dispute that it hasn't improved. There's some dispute about whether it's actually worsened. We submit it doesn't make any difference. What's significant is that it's common ground that there has been no improvement, and that shows that it is not the weaker claims that are being weeded out. And the aim of seeking to prioritise stronger claims has not been met at all by this legislation. And this, again, we can see from the review, Appendix Part 5, it's page MS 1853, and in the internal numbering, that is 1599.
Thank you.
Table 8.
Yeah.
And without taking time on it, if the court looks at that table, you will see a clear fall in the success rate after the introduction of the fees. And you will also see in the same table...
we're seeing it by reference to when they were decided, not when they were
That's
issued.
right, my Lord. Yes, that's right.
So there will be a sort of...
There's a tail.
There'll be a tail,
That's
exactly.
right. But if you look at 2012-13...
Those were pure...
Those are pure
old style
cases. Yeah. And you see the success rate there is somewhat higher.
Yep.
Also, the number of claims with an unsuccessful outcome, the proportions are lower. Also, look at the figures for settlement. Again, you can see that there has not been an improvement in the settlement rate, on the contrary.
What is the normal type of period between issue of proceedings when the fee would be paid and determination. Obviously, it can vary enormously between whether it's settled, whether it's complicated and so on. But what sort of...
On average, about 6 months, my lord.
6 months. So by the time we get to the last lot of figures, there's little if any tail there.
That's
Thank
right.
you very much.
That's right. And so you can see from this why it is that they don't dispute that there's been any improvement. And we also draw attention to the point about the settlement rate. No improvement in the settlement rate. We deal with that in detail in our written case. Can I just give you the reference? It's core bundle, page 91,
Yep.
paragraph 64.9.
Yeah, I remember reading that. Yeah.
And that refers to the spreadsheet, which is in Appendix Part 5, page 1748.
Yeah. You could go to a bit
Now,
more
the
detail.
respondent's answer to this point is in their written case.
Yep.
Core bundle MS 182, it's paragraph 133.
Thank you. They just challenge the fact that things have fallen rather than anything else.
Well, they don't, my lord. This is on settlement rates.
Yeah.
Although they say this is wrong, they say they don't challenge the figures. They say they don't accept that it's a fair representation because there was a large multiple airline claim that was struck out. They don't say the figures are wrong. Then they say actual settlement figures may not be indicative of the degree of success of this policy. If the parties have agreed to engage in conciliation and in fact no settlements reached but no proceedings are issued, this too is capable of being a positive outcome. Now, well, that's all very interesting, but it's not actually a challenge to the data.
It doesn't deal with the number of unsuccessful
No,
claims.
it doesn't.
Understood.
Now, so, my lord, those...
We don't know what proportion those airline claims are anyway.
No.
They haven't given us the figures.
No, my lord, that's true. And so, my lord, the...
Is there any way of finding out, do you know? Well, it's not. You would say it's not for you to do that.
It's not for us to do that,
Okay.
my lord, and in any event, in any given year, you will always have a certain number of large claims and matters like that. That's just part of the way that figures are. Yeah. There's no such thing as an entirely typical year. Now, that brings me then to the legal framework. So those are the key factual effects of the policy that I wanted to identify to the court. I'm now going to come to the question of the proper legal framework under which this situation should be addressed.
Just to interrupt, many of your points are not points which were available for the Court of Appeal.
That's right, my lord.
Could it be said that we're now considering whether the policy should now be reconsidered rather than whether it was wrong initially? I mean, you can have a policy, it's entirely justifiable because you can never know what's going to happen. And this argument, it could be said, is slightly different from the argument that you were running. I'm not saying it's therefore wrong, but what you're really saying is this policy, this argument, you would say, shows that the policy hasn't worked, hasn't achieved its aims, or can be shown now to be unfair. Is that a sort of different argument from that which is being...
Well, my lord...
not merely new facts, but it's a different...
It's not a
whole different concept.
Yes, my lord, this is always the tension that arises, given what the court has said in previous cases about the need for proportionality to be considered at the date of the hearing.
Yes.
And there is a tension there, and I'm not aware of any case that's really grappled with that tension or sought to resolve it. How do you reconcile the traditional public law exercise, which is asking whether a particular decision of a public authority was lawful, with the assessment of proportionality at the date of the hearing by the court?
Presumably you'd argue in any event that the demonstrated deficiencies point to a failure to investigate in advance and to address what were readily anticipated difficulties.
Of course, the reality, that's right, my lord.
Except the facts weren't there.
But some of the facts were fairly obvious and were pointed out. It was known within a very short period of time that there'd been a dramatic fall in the number of claims. And that data became available within a matter of months of the new fees coming in. So that key fact was known. It's true that the ACAS data showing the number of people who said they couldn't afford it came in later. But things like no improvement in the success rate, that was known. A lot of this material was known. We just simply now have more data that gives a consistent picture over a longer period of time.
Anyway,
and the disproportionality of the fee to the small claim is an obvious point. You don't need evidence to deal with that.
Your point ultimately is that proportionality has to be judged by reference to the date the decision is made.
Well, no,
So,
my lord.
our decision is made,
Yes,
right? The
yes,
court
yes,
decision
yes.
is made. Sorry, I wasn't clear. Yeah.
Yes, that's right, my lord.
Because your challenge is not in this case to an individualised decision, but to the continuation of the system.
Yes, which we say should be quashed.
Yes, you
Well,
focus
quash
on-
would be retrospective, wouldn't it?
Yes, it would.
Ms. Reyes?
It would, my lord, but
My Lord has simply said you're objecting to the continuation. You said you were, then you said you wanted us to quash it. That would go right back for 3.5 years.
It would, my lord. And of course, that's always going to be the position when you are objecting to legislation on the basis of a proportionality challenge, that you'll be looking at the evidence before the court as a basis for challenging the legislation. And as I said, I'm not aware of a case from this court that's actually confronted that.
Well, that's why I raised
It
it.
comes from the misbehaving approach.
Yeah, but it does raise a question
It
about
does.
quashing.
Can I shelve it for now?
Okay.
Because
You want to go to the law? Fine.
I do.
You
need
can
to,
shelve
but
it, yeah.
it is an extremely important point, my lord.
Yep.
So, can I start with the common law? The position is that, as we've seen, the 2007 Act gives the Lord Chancellor a general power to add tribunals for which fees may be charged and to set the fees for those tribunals. That legislation, we submit, gave no authority to the Lord Chancellor to set fees in a way that constitutes a disproportionate interference with the right of access to justice. And in the absence of an express provision in the clearest possible terms, crystal clear terms, permitting such legislation which has that effect would be ultra vires. That's the submission as a matter of common law. And we say that this follows from a consideration of the case law, which has long recognised the right of unimpeded access to justice as a constitutional right at common law, and which now recognises that, and indeed we say, going back at least to cases such as ex parte Leach, has recognised that as a right which can be restricted only where it is specifically authorised and where the restriction is proportionate. Now, I recognise that theoretically Parliament could legislate in such a way that permitted a disproportionate interference with the right of access to justice. But that would engage the principle of legality and would have to be done in the clearest possible terms in the primary legislation.
Does the affirmative resolution of this order present problems for this argument?
No, my lord. We say it makes no difference because under the affirmative resolution procedure, Parliament has no power to amend the legislation. It's simply a question.
I think there's clear authority on this.
Yep.
There is, yes, there is.
Yep.
So can I now turn to a case which we say is of great importance in this analysis, which is the decision in ex parte Leach. It's at volume 6, tab 86. The MS number is 4093. And this is a decision of Lord Justice Steyn, as he then was, for the Court of Appeal. And it concerns secondary legislation and prison rules which permitted prison governors to intercept and read communications between prisoners and their solicitors. Yeah. And if we go to page 4097 in the MS numbering, we can see the issue at E, whether Rule 33.3 is ultra vires section 47 of the Prison Act, on the ground that it permits the reading and stopping of confidential letters between a prisoner and a solicitor on wider grounds than merely to ascertain whether they're in truth bona fide communications between solicitor and client. And if we go then to 4105, at the top of the page, Lord Justice Steyn describes the principle that every citizen has a right of unimpeded access to court, and describes it as a constitutional right and refers to Raymond and Honey. And then at 4110, Lord Justice Steyn addresses the argument of the Secretary of State, who was relying on a Scottish case where a similar argument to that mounted in Leach was rejected. And Lord Kaplan, in the Scottish case, said, "I'm not aware of any indication in our law that a prisoner is entitled to communicate with his solicitor by the particular means of correspondence. What's essential is the prisoner should have the opportunity for private communication." And what's then said at 4111 is the logic of this reasoning is that a rule which authorises a governor to withdraw the right to conduct legal correspondence entirely from prisoners would be lawful, provided that the rules allow prison visits by the solicitor. A prisoner can choose his solicitor, but he cannot choose his prison. If he's detained on the Isle of Wight and his solicitor practices in Newcastle, the withdrawal of the prisoner's right to correspond with the solicitor could seriously impede his access to justice. And I stress the word impede, not destroy or defeat. It's part of the ratio decidendi of Raymond that Section 47 does not authorise denial or interference with a right of unimpeded access to court. It's part of the ratio decidendi of Anderson that unimpeded access to a solicitor for the purpose of receiving advice and assistance in connection with a possible institution of civil proceedings forms an inseparable part of the right of access to the courts themselves. Section 47 does not authorise the creation of an impediment, I stress impediment, to the prisoner's right of access to a solicitor. The question is whether Rule 33.3 creates an impediment to these basic rights. Frequently, it may not be possible for a solicitor to visit a prisoner as soon or as often as may be required. Correspondence will often be the most effective medium for giving advice. And then in Solosky and the Queen, Mr. Justice Dixon described the impact of a right to read a prisoner's correspondence as follows: "Nothing is more likely to have a chilling effect on the frank and free exchange and disclosure of confidence which should characterise a relationship between inmate and counsel, the knowledge that what's being written will be read by some third person. We respectfully agree an unrestricted right to read correspondence from a solicitor to a prisoner must create a considerable disincentive to a prisoner exercising his basic right. In our view, it's a substantial impediment to the exercise of the basic rights." Now, the reason I stress that passage is because the Court of Appeal are not suggesting in Leach that the right to read correspondence would destroy the right of access to justice or make it impossible for prisoners to access justice. What the court is identifying is an impediment or a restriction that has a chilling effect or a disincentive on the right of access to justice. And we submit that's very important. And it's one of the reasons why we say that the test applied by the Court of Appeal in this case, which was a test of impossibility of accessing justice, is the wrong test. Now, the reasoning in Leach was then applied to court fees in the Witham case. That's at Volume 1, Tab 9. We go to page 2305. So this was a case of the imposition of fees for civil litigation without any provision for remission on the basis of financial hardship. So it's an easy case in the sense that there is obviously a complete denial of access to justice for those who cannot afford it. And if we go to 2305, we can see the nature of the argument at the bottom of the page. The primary submission is that there exist implied limitations on the Lord Chancellor's power to prescribe the fees, and the reference to the constitutional right of access to justice. And then at 2307, Lord Justice, or Mr. Justice Laws as he was then, discusses the right of access to justice as a constitutional right, and he cites the Bremer-Vulcan case, which is in the bundle in this case, and he also cites ex parte Leach over the page at 2308. And at the bottom of 2308, he says, I would at this stage make two observations about the impact of this reasoning on the issues this court must decide. Mr. Richards, who was for the Secretary of State, submitted that the present case is not analogous to a situation where access to the court is directly interfered with, as by placing impediments on a litigant's communications with his solicitor. I do not understand how that can be so. In ex parte Leach, a general rulemaking provision was relied on as authorising a regulation which permitted the censorship of a prisoner's correspondence. Nothing in the Prison Act made specific reference to the position where a prisoner was communicating with his solicitor. Likewise, Section 130 makes no specific reference to the position where a person is prevented from access to the court because he cannot pay the fee. And then this, if anything, the present case is a fortiori ex parte Leach. It was not the consequence of the rule there under assault that the prisoner was disabled from going to court altogether. And, my lords, my lady, we say that's very important because Mr. Justice Laws is there correctly recognising that Leach is not a case of a complete denial of access to court. It's a case of a restriction on access to court, a chilling effect on access to court. He then goes on to consider Strasbourg, and this is at page 2311. At D, he says, it seems to me the common law provides no lesser protection of the right of access to the Queen's courts than might be vindicated in Strasbourg, and we say that subsequent case law makes it abundantly clear that that is correct. And then at 2312, at F, he says the effect of the order is to bar absolutely many persons from seeking justice from the courts. And on that basis, he says that the order is unlawful. But of course, it doesn't follow from that if the effect of the order had merely been to amount to a substantial impediment to the right of access to court that had a chilling effect on the bringing of otherwise meritorious claims, that the order would have been held to be lawful. And my submission in that situation, which would have been closer to the Leach analogy, the question would have been one of proportionality, whether the restriction was proportionate. Now, the next case is Hillingdon, which is in the same volume at tab 12. Yep. And again, a decision of the Court of Appeal, Lord Justice Dyson. And in this case, as we can see from the headnote, court fees for public law childcare applications and placement order applications had been massively increased. Now, these are fees that were paid by public authorities, by local authorities. It's obvious, therefore, that the sorts of bare affordability considerations, which were regarded by the Court of Appeal in this case as being the only relevant question, cannot have been in play in Hillingdon, because these were public authorities. And indeed, what happened was that, in fact, the Secretary of State made an increase, the government made an increase in the formula grant for local authorities of 40 million that was intended to cover the increase in court fees. And we see this at the bottom of the page here. What, in fact, the government was seeking to do was more efficiently to reflect pricing as between government departments, so that if a social services department in a local authority was seeking to bring a court application, they should reflect on the true cost, because that would give them a more efficient incentive when deciding whether or not to bring the application. That was the rationale for what they were seeking to do. And the test applied by the court, if we go to paragraph 60, this is Lord Justice Dyson, as he then was.
Yeah.
Now, he describes it as a question of irrationality. My submission, if he were deciding this case now, he'd look at it under the head of proportionality. He said, during the course of argument, it became clear the essential issue raised by this question was whether charging the full cost involves a real as opposed to a fanciful risk that the interests of vulnerable children will be jeopardised by the policy. There was argument before us as to the correct approach. Mr. Grodzinski submits that the question is whether it follows from the fees orders that local authorities will, or that there's a real risk that they will, be required to act inappropriately by not making applications. In other words, compelled to act inappropriately. Mr. Supperston and the interveners submit that the correct question is whether, as a matter of fact, the increase in fees will, or there's a real risk that they will, cause local authorities not to make applications which objectively should be made. I doubt whether in practice there's much, if any, difference between the two formulations, but to the extent that there is any difference, I prefer the latter formulation. The fees orders may not oblige local authorities to act inappropriately, but their impact must be considered in the real world. In my view, the relevant question is whether there's a real risk that the increase in fees will cause local authorities not to make applications which objectively should be made.
Does that mean, when you say there's a real risk that that will happen,
Yes.
that you're really satisfied that it will actually happen in some cases? There's
Yes.
a real,
Yes.
because if you could say there's a real risk, but it'll never happen.
Exactly.
It's got to
Yes.
be satisfied that it will happen.
There will be cases where meritorious claims which ought to be brought will not be brought. And I would go further and say that it must be a feature, it must be a systemic feature of the scheme, not the result of an individual parent decision. It must be inherent in the way that the scheme functions. But the key point here, again, is that the test that's being applied is not whether it's impossible for the local authorities to fulfil their statutory duties, but whether, as a matter of reality, the incentives or the disincentives that will follow from the imposition of the scheme are such that they won't make applications which ought to be brought. It's a question of fact, not a question of impossibility. And the conclusion on the facts was that given the transfer of the amount of money, given their statutory duties, they would make the applications that needed to be made, and that therefore the scheme was lawful. Now, these cases that we've been looking at don't expressly use the language of proportionality at common law, but, of course, more recently, this court has moved to the position where it is now recognised in cases such as Kennedy and Pham that a proportionality test in substance is appropriate when considering legislation, and particularly secondary legislation, that interferes with a fundamental constitutional right at common law. And I just want to look at the Pham case, which is in Volume 2, tab 14. This, of course, following on from the decision in Kennedy and the Information Commissioner, and developing the reasoning in Kennedy a little further. And the issue in this case was about the removal of citizenship from a particular individual originally from Vietnam, and the question was whether the result would be to leave them stateless. And one of the questions that was raised was whether there would be any difference in the way that SIAC considered the application if they were only considering the removal of citizenship at common law, or if they were considering it also as a matter of EU law in relation to EU citizenship. And the conclusion of the Supreme Court was that this was a matter for SIAC, but the likelihood was that it would make no difference, because the substance of the question and the substance of the test would be proportionality, whether you looked at the matter as a matter of common law or under EU law. And we see this first from Lord Carnworth, paragraph 59, page MS 2444. Paragraph 60, he addresses Kennedy and the judgment of Lord Mance. And quotation about reasonableness review and proportionality both involve considerations of weight and balance, intensity of the scrutiny and weight to be given depending on context. These considerations apply with even greater force in a case such as the present. And then we see Lord Mance, paragraphs 93 to 96. In particular at 94. And then over the page again at 96. And Lord Sumption 2456 to 7, paragraphs 105 to 110. And in particular, an interesting discussion of whether, as a matter of common law, the court is limited to considering the reasonableness or whether it can directly assess proportionality. And he concludes that there are circumstances where it can directly assess proportionality, and that's 107 to 108. And then finally, Lord Reid, paragraphs 117 to 119. And Lord Reid at 118 specifically refers to justifications advanced for interference with the legal rights, including the right of access to justice. And as the court can see, refers specifically to the case of Leach as a case which adopts an approach that amounts in substance to a requirement of proportionality, though less formally structured.
Yep.
And at 119, one can infer from these cases that where Parliament authorises significant interferences with important legal rights, the courts may interpret the legislation as requiring that any such interference should be no greater than is objectively established to be necessary to achieve the legitimate aim of the interference in substance of requirement of proportionality. And we would submit that that reasoning applies in the circumstances of this case. So that's the position in our submission of common law. Turning then to the Strasbourg jurisprudence, we accept this is not a Human Rights Act claim because this is not a claim brought by an individual victim, it's a claim brought by UNISON. But as Mr. Justice Laws rightly pointed out in Witham itself, common law is at least as favourable as the Convention in protecting the right of access to justice, and therefore one can take the Strasbourg authorities as establishing a floor of the minimum level of protection that is acceptable for that particular right.
Yep.
And the Strasbourg cases have considered the lawfulness of court fees on a number of occasions. In fact, there's a huge mass of case law.
Well, we've seen a number of them referred to in the written cases.
Yes, my lord, your lordship has. Now, the leading case, the first case that sort of is cited in all the other cases, is a case called Kreutz, which is in volume 2, tab 21. And I am going to take these cases rather rapidly for the very reason identified by Lord Neuberger.
Well, we have more than once.
Their number is legion, but there are some points I need to make. And the complaint here was that the applicant had wanted to open a car wash and he got into a planning dispute with the local authority, which had wrongly refused him planning approval for his car wash. And as a result, he said he'd been unemployed and lost a lot of money. And he wanted to sue them for damages. And he wanted a waiver of the court fees. And the legal analysis, which is then essentially recycled in many subsequent cases, is at paragraphs 52 to 60, starting at page 2632.
Okay.
And essentially what is said is Article 6 protects the right of access to court, that's paragraph 52. The right is not absolute, but may be subject to limitations. And then at 54, it's possible to have financial limitations on the right of access to court. However, mustn't restrict or reduce the access afforded to the applicant in such a way or to such an extent that the very essence of the right was impaired. And then at 55, the court underlines a restriction placed on access to a court or tribunal will not be compatible with Article 6 unless it pursues a legitimate aim and there's a reasonable relationship of proportionality between the means employed and the legitimate aim pursued. And we say that's the obvious test, it's always the test. And there is no basis, with respect, for the approach taken by the Court of Appeal or by the respondents in this case for suggesting that a different test, limited to affordability, should be applied in relation to access to justice. And then at 57, again, another important point, that the Convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. Again, it's a tagline with which this court will be very familiar, but we say one that's very much in play on the facts of this case. That to have a theoretical right to access an employment tribunal, which no rational person would exercise, is of no comfort to anybody. And there is then the point at 60. They say that the requirement to pay fees to civil courts in connection with claims lawsuit cannot be regarded as a restriction on the right of access to a court incompatible per se with Article 6.1. However, reiterates that the amount of the fees assessed in the light of the particular circumstances of a given case, including the applicant's ability to pay them and the phase of the proceedings of which the restriction has been imposed, are factors that are material in determining whether or not a person enjoys his right of access. Nowhere in any case has it said that they are the only factors that are material. They are merely examples that are given. And there is then, starting at paragraph 61, going all the way down to 67, an application of those principles to the facts of the case. And the court will see a number of reasons why the Strasbourg court concludes that the restriction is disproportionate in this case. First of all, at paragraph 63, they say, okay, he was a businessman, but this claim is only loosely related to his business activity. Then, just above the letter D...
That's saying that it's not enough, that he's no income because the business has failed.
That's right.
Then you go on.
Then they say, the findings in relation to his financial situation based on his hypothetical earning capacity rather than on the facts he supplied. Then at E, they refused to accept his argument he was unable to pay the fees without obtaining or considering evidence contradicting the facts he stated in his declaration of means. Then at paragraph 66, assessing the facts of the case as a whole and having regard to the prominent place held by the right to a court in a democratic society, the judicial authorities have failed to secure a proper balance between, on the one hand, the interest of the state in collecting court fees for dealing with claims, and on the other hand, the interest of the applicant in vindicating his claim through the courts. The fee required was excessive. It resulted in his desisting from his claim, and his case never being heard. That impaired the very essence of his right of access. So the crucial determinant points are, one, the fee was excessive, and two, as a matter of fact, it deterred him from pursuing his claim. And there are then a number of cases...
Was the ratio of court fee to claim particularly absurd?
It was, the fee was large. I'm just trying to find the... But these are old-style zlotys, which I have struggled with trying to work this out as 200 million. One old-style zlotys in 1994 were exchanged at a rate of 10,000 to 1 for new-style zlotys, which in the later 1990s were about 5 to the pound, suggesting that the old-style zloty was somewhere in the region of 50,000 to the pound. Now, on that basis, you can work out that he was seeking, well, you have to divide the whole claim by 50,000.
Well, he was saying, if it's any help, at 38, that the fee was about an annual average salary in pounds.
Yes, yes. So it was a pretty hefty.
However many zlotys it might be at any particular time, that's the sort of level.
I mean, I worked out it was about £2,000, which makes you worry for the standard of living in Poland. But I don't claim any authority for the relevant.
Very well, thank you.
They also say, don't they, at 64. That the domestic courts didn't do him justice in assessing his means.
That's right. So that's the facts of that case. And if we then, I just then want to show very briefly the court some cases where there's a finding of breach, notwithstanding the fact that the individuals actually did have assets. And the Nyat case, which is in volume 2, tab 20,
Right.
This was a matrimonial case. And if you go to page 2612,
Yep.
you can see that the applicant was appealing against the divorce decree. She contested the findings in respect to breakdown of marriage and her being responsible for the marital breakdown. So it was an issue of, it was a contested divorce, and it was about her status.
And we're back to zlotys. These are new zlotys.
These are new style zlotys, which is why they're much smaller than the old style zlotys. I think it may be zlotys, but I don't want to get into a pronunciation fight with my lady. So the...
We've enough to worry about without worrying about
No, my
how to
lord.
pronounce
So
a defunct
I
currency.
can't remember how they were pronounced in 1966 when I was last in Poland.
so the claimant in this case had resources. And we see this if we go to paragraph 14,
Zloty. Yep.
where the regional court held that she hadn't shown her financial situation made it impossible for her to pay the fee.
Yep.
And then at paragraph 31, page 2615, she stressed that the courts assessed her financial situation on the basis of the lump sum of 300,000 zlotys that she'd received in the proceedings for the division of marital property. So she had a substantial sum. We assume 5 of those to the pound. That was a pretty hefty chunk of cash.
Well, yes, but she's trying to set the divorce aside.
Well, I don't think she was trying to set it aside. She was trying to say it was his fault rather than her fault for adultery.
Oh, I see.
The reasons why that matters as a matter of Polish law don't need to trouble us. But if we then look at, so the principles you can see at 38, they say you get from the Kreutz case.
Yeah.
And then they apply the principles, and they make the point that this isn't a pecuniary claim, but concerned the applicant's civil status.
Yeah.
And then over the page, they point out at 42 that there was a lot at stake for her in terms of her civil status.
Yeah.
And then at 44, second indent, they say, in the present case, the court considers the judicial authorities refused to accept her argument she was unable to pay the court fees. They assessed her financial situation solely on the basis of the lump sum that she'd received or was to receive from her ex-husband. In this respect, the court observes that the applicant received payments from her husband for her share in the party's matrimonial property. Nevertheless, this sum constituted apparently her only asset. It did not seem reasonable to demand that she spend part of it for court fees rather than build her future and secure her and her minor children's basic needs after the divorce. And then they say, assessing the facts of the case as a whole, having regard to what was at stake, the court considers that the judicial authorities failed to secure a proper balance between the interest of the state in collecting court fees and the interest of the applicant in pursuing her appeal. Now, that cannot be a case based on bare affordability and inability to pursue in the sense that the Court of Appeal raised it. What the court is saying is it's not reasonable to ask her to spend the amount that she received from the matrimonial proceedings to secure her future on establishing her civil status. Now, there's an obvious parallel there between that situation and the situation we considered earlier of a claimant who has been made redundant and claims that the redundancy is an unfair dismissal or discrimination and is required under our own scheme to spend the redundancy payment on the court fees. A much, much smaller sum than the claimant had in this case.
It's a very small percentage, wasn't it? Have I got it right? 10,000 zlotys? And this was an appeal. She'd had a hearing.
Yes, yes. So it's a far lesser interference than the sort of interference we're looking at in our case. Now, one of the points that's made by the respondent in their written cases, they say they're not aware of any case between private parties in Strasbourg which doesn't turn on bare affordability. Well, this is an example of such a case. And there's another one, which is the case of Kordos, which is in volume 9, tab 121.
I mean, what do we deduce from this for the present sort of case? I mean, if one is really going that far, what should court fees have been in the present case?
Well, my lord, of course, the Strasbourg court doesn't say what they should have been, and neither Do your lordships have to say what they should have
Well,
been?
it might be,
Your
it might be
lordships.
helpful to know how far one is off what would be acceptable.
Well, yes, and my lord, the answer is that they must be set at a level which properly balances the interest of the state in receiving income against the interests of individuals seeking access to justice. And ultimately, that's an evaluative question. It's not a question that the Court of Appeal, the Divisional Court, ever considered in this case.
But you've given us some examples of cases where
Yes.
people have received redundancy payments or payments in lieu of wages.
Yes.
If one applied this sort of reasoning, then one might say, well,
So they should be excluded from the capital.
yes, completely. I mean,
Yes.
any court
Absolutely.
fee would be unreasonable.
Or no, it wouldn't follow that any court fee would be unreasonable. It would follow that if you were assessing people's means, you shouldn't take into account any sums that they'd received in settlement or been awarded by...
Except that in that case, A, she'd offered to pay 30%,
Yes.
and B, the importance of the case to her were factors that were taken into account.
Indeed, my lord. And of course, the importance of the rights at stake is a factor I'm going to come on to
Right.
later, because
Yes.
there are very important rights that are at
I mean,
stake
one
in
of
these cases.
the difficulties might be said is that I think I'm right in saying that the Strasbourg cases all involve consideration of individual
They do.
claims.
They do.
Here we are being asked to consider
I agree.
across the board.
Your lordship's right. And of course, that's the nature of the Strasbourg jurisdiction, that you're always looking at complaints made by victims, or they couldn't be in Strasbourg at all. And that is a difficulty of read across from the Strasbourg case law to our own. Can I just very briefly deal with some key cases? We may not need to turn to them all, but just to give your lordship the reference.
I mean, if you've summarised them sufficiently in your written case, that may be a more efficient way to deal with them.
Yes.
Up to you.
Let me just take my course here, my lord. So the Cordos case, which we don't need to turn it up, it's at volume 9, tab 121.
Yep.
It's very similar to the Niat case, and also reaches the conclusion that it's not reasonable to expect the individual to spend their lump sum on the fees. Then the case of Stankoff, which is at volume 2, tab 24. This is...
Well, we know that for a different reason, don't we, Stankoff?
I don't know, my lady.
Well, isn't that about deprivation of liberty?
It is, yes.
Yes.
It is.
Well, in our big case about deprivation of liberty, of course, we looked at the substance of the Stankoff case.
Well, so this was a case about wrongful imprisonment. It's at tab 24 in
Is
volume
this the
2.
retrospective fee?
Indeed.
Yeah.
And my lord, again, very important because it cannot be about bare affordability, because the whole starting point in Stankoff is that he had brought his claim, he had been successful, and he had been awarded compensation. And the complaint was that the amount of the court fee that he was being asked to pay at the end of the proceedings was 80% of his compensation.
Well, there might be some objection to that, quite apart from the amount, mightn't there? If you've pursued your claim, you've got home, and you've succeeded. Anyway,
Absolutely.
that's what
But,
it is.
My lord, I don't put it forward on the basis that it's identical to the facts before this court. I put it forward to show that the approach of the Court of Appeal is wrong, because the Court of Appeal says everything's irrelevant except bare affordability and inability to go to court. And this is obviously a case which is not about that, because he had been to court.
What's interesting about Stankoff is that they look at the comparative law.
Yes, they do.
And we're not doing that in this case.
No, my lord, we're not. But of course, they are there seeking to operate as an international court and ask whether the particular member state has exceeded its margin of
but if
appreciation.
we're relying on Strasbourg, we're relying on Strasbourg.
Yes. But, my lord, as I've said, we say it's the floor, it's the minimum standard. And this court might take a somewhat more intrusive approach, since it is not an international court, but the Supreme Court considering delegated legislation that touches on a fundamental constitutional right. Now, the key passages in Stankoff, 2, 6, 7, 8. Starting at 51.
Yeah.
And it goes down to paragraph 67.
Pretty extraordinary.
And in particular, the court will note at paragraph 52 We have the familiar formula from Kreutz, but here without reference to affordability, not surprisingly, because this is not a case about affordability. So it says, the amount of the fees assessed in the light of the particular circumstances of a given case is a material factor in determining whether or not a person enjoyed his right of access. And the footnote references Kreutz, but we don't see a reference there to affordability. And in my submission, this is a clear indication that, as you would infer from the original wording of the formula, it's not limited to affordability. It's a proportionality analysis taking into account all the relevant circumstances. And the relevant circumstances may be different from case to case.
Well, does that mean, how far does that go? Does that mean in the present circumstances, court fee does have to depend upon prospects of success as well as the amount claimed and all the other aspects?
My Lord, it doesn't mean that a court fee has to be based on that. What the Strasbourg case law tells us is that it will be more tolerant of court fees that take into account the merits. That comes from the Tolstoy-Miloslavsky case. And the court says it will apply a particularly rigorous scrutiny to court fees that are unrelated to the merits.
But that isn't a court fee, is it, the Tolstoy?
No,
that's security for costs. And when you're talking about legal aid and security for costs, yes, you do look at the particular case, but court fee by definition is something that's bound to be a bit rough and ready, isn't it?
Yes, my Lord, that's right. But what the court says is in that situation where you're talking about a purely financial restriction that is not related to the merits of the case, the court will apply a stricter scrutiny. It doesn't say you can't do it, but it will apply a stricter scrutiny. Now, what the respondents say about this case is that it is based exclusively on the fact that this is a claim against the state and that the state can't give with one hand and take away with the other. We say that is obviously a misreading of the case. The fact that this is a claim for wrongful imprisonment against the state is one of the factors that's considered by the court, and you can see it considered at page 2679. But it is only one of the factors in the overall proportionality analysis. And in particular, what we see at 2680, paragraph 62, they discuss the fact that he had overstated his claim, and they say, well, he shouldn't be blamed for that because it's very difficult to accurately assess the claim in advance. And then at 64, the financial burden was particularly significant because the legislation imposed a flat 4% rate with no upper limit and no room for any judicial discretion. Owing to the difficulty assessing likely awards of non-pecuniary damages, as a result of its automatic and post hoc nature, the impugned court fee system has effects not necessarily intended by the legislator. Dispensing with the requirement of advancing the court fees removes the cautioning effect such a requirement may have on claimants. Then they refer to the fact that different solutions are adopted by different states, and they say that the conclusion is that although the imposition of court fees is an aim which is compatible as such with the good administration of justice, the practical difficulties in assessing the likely award, taken together with the relatively high and wholly inflexible rate of court fees, amounted to a restriction on the right of the court which was not proportionate. And we say it's simply wrong to suggest that that case turns on the fact that it's a state, the state that's the other party to the claim. It's not the basis of paragraph 67. It's an overall proportionality analysis. Similar case is Dimitrov, which we don't need to turn up, but it's at volume 9, tab 115, and that's significant because the amount of the court fee was much lower in that case, but the analysis was the same. Then there is the case of Weissman, which is at volume 2, tab 25. This is another case where the issue cannot be... Now, I think the version that's in your bundles is the wrong report, and the court should have been given a small supplementary bundle that has the right Weissman in it. This morning, a small clip of authorities. If they could be handed up.
sorry, I was wrong. Stankov was not the case I was thinking about. There was another one beginning with an S against Bulgaria, which was relevant. And I thought this might have been the follow-up to it.
It's a different individual.
My mistake. Was it?
Yeah.
This one.
No.
Now, again, Weissman cannot be a case about bare affordability because it started with a successful claim for the restitution of a very substantial property. And we see that at paragraph 9. The Weissmans had brought a claim for the restitution of real estate consisting of a building and the adjacent land in Bucharest occupied by the Embassy of the Federal Republic of Germany, so we can infer that it was a rather substantial asset. And they obtained restitution of that building, and they then brought a further claim for unpaid rent for the years that their property had been wrongfully occupied by the state. And the complaint about the court fee was about the court fee to enable them to bring the claim for unpaid rent. And if we go to paragraph 30, you can see the Kreutz test is repeated. And then at 35, they say they don't rule out a financial restriction. They apply a proportionality test. They refer to the need to have practical rights. And then they simply say that the failure to pay resulted in the cancellation of the action. They say it was a very high amount for any ordinary litigant and wasn't justified by the particular circumstances of the case or the financial position. It was calculated on the basis of a set percentage. And at 40, they say the amount was excessive. As a result, they were implicitly obliged to abandon the action, which deprived them of the right to have their case heard by a court. Now, there's no finding anywhere here that they couldn't afford to bring the claim, and that would have been very odd, given that they just had restitution of the German embassy. It's simply a finding that the fee is disproportionate and excessive. And finally, the case of Kakir and Turkey, which is at volume 8, tab 112. And this was, in fact, an employment dispute for unpaid salary, where the claimants had been successful, but then were being charged a fee for the final version of the judgment to be handed over to them so that they could enforce it. And if you go to paragraph 20 at 4985, the domestic court imposed on the applicants a financial obligation, failure to comply with which barred their access to the judgments concerning their unpaid salaries, and thus the further enforcement proceedings. That obligation, which should have been borne by the other party, and which was imposed on the applicants at the enforcement stage, constitutes restriction of a purely financial nature, therefore calls for particularly rigorous scrutiny from the point of view of the interests of justice. That's the point I was making to my Lord Neuberger earlier, that if it's a pure financial restriction not related to the merits, the court applies particularly strict scrutiny, and that derives from the Apostol case. And then at 21, the court reiterates the fulfilment of the obligation to secure effective rights under Article 6 does not only mean the absence of interference, but may also require positive action on the part of a state. By shifting to the applicants the full responsibility to meet the court costs, the state avoided its positive obligation to organise a system for the enforcement of judgments effective both in law and in practice. Some consideration should also have been given in the present case to the reasonable relationship of proportionality between the payment of the court costs and the work required for the task in hand, of merely providing the applicants with a copy of the judgment, and the finding is excessive burden, restricted the right of access to the court, impaired the very essence of the right. And again, an analysis that's not based on affordability, but based on the excessive burden. even though it's a small fee.
It contains the proposition, does it, that it's part of the state's obligation to have
an effective system.
To have a national system of enforcement beyond paid for by the judgment creditor.
Yes.
Mm.
Well, why doesn't that apply to all aspects of the justice system? By shifting to the claimants, just transposing the full responsibility to meet the court costs, the state avoided its positive application to organise a justice system which is effective in law and in practice.
That might be so, my lord. It would depend on the proportionality of the fees being charged. Everything always comes back to the question of proportionality. And the only point I'm really seeking to make here is that the test is an assessment of proportionality in the round. Can I just summarise what we say are the principles that one derives? They
say that merely providing the applicants with a copy of the judgment, they go on to say...
Yes, it's disproportionate.
Yes.
Yeah. Can I just summarise what we say are the relevant principles? First, we say that the Strasbourg case law does not support the proposition for which the respondent contends on this appeal, that the test for compliance with Article 6 is solely focused on the question whether the applicant can afford the fee. On the contrary, the court applies the usual proportionality analysis that you would expect under Article 6, looking at all the circumstances of the case in the round. And as we've seen, there are a wide range of different circumstances in different cases. Thirdly, we say the cases are notable for the particularly rigorous scrutiny applied by the court in certain circumstances, and I identify the following where the court applies rigorous scrutiny. First, where the restriction is purely financial and not based on the merits. Second, where the restriction is imposed at the very outset of the claim, so that a failure to pay bars access to court entirely, rather than on an appeal or at a later stage. Thirdly, where there is no discretion in the court to vary the fee. And fourthly, where there's no relationship of proportionality between the fee and the claim. Finally, the court regards it as unreasonable to require a person to exhaust their only asset to pay a court fee. So those, we say, are the principles that you derive from the convention case law. Now, so far as EU law is concerned, I propose to take this very lightly. The starting point is the Charter of Fundamental Rights, Article 47 of which guarantees the right of effective access to court expressly, and Article 52 of which says that that right may be interfered with only insofar, first, as its essence is respected, and secondly, insofar as the restriction is a proportionate means of meeting a legitimate aim. And Article 52 also requires that EU law should be at least as favourable as the Convention. So that, again, we say, establishes the Strasbourg case law as a baseline, as a floor. Now, one case, of course, the EU Charter did not in itself create new rights. It merely codified rights that had been available in the European jurisprudence beforehand. And the right of effective access to justice had already been invoked by the ECJ in a number of cases. And I just want to show the court one, which is the case of Coote and Granada Hospitality. That's at volume 3 of the authorities bundle, tab 29. This was a sex discrimination case. What had happened was that the claimant had brought proceedings against her employer for sex discrimination, which was settled. And she had left the employer's employment by mutual consent on the settlement of her claim. And subsequently, she had asked her former employer to provide her with a reference. And her complaint was that they had refused to provide a reference because she had brought a complaint of sex discrimination. And she wished to complain that she'd been victimized for bringing a claim of discrimination. Under United Kingdom law at that time, a claim of victimization could not be brought by somebody who was no longer employed by the employer. It could not relate to an act that post-dated the termination of employment. And the question was whether, as a matter of European law under the Equal Treatment Directive, the claimant ought to have had a right, the United Kingdom was under an obligation to provide her with a right to bring a complaint of victimisation relating to action after the end of her employment. So one can immediately see the radical nature of the proposition, which is that there is an obligation on the United Kingdom to establish a substantive cause of action, which doesn't exist in UK law, the right to post-termination victimisation. And the court held that there was such an obligation, and it based it on the right of effective access to justice. And we see this if we go to page 2747. Paragraph 19. So the questions put must be understood as seeking to ascertain, for the purposes of the Equal Treatment Directive, whether the directive requires member states to introduce into their national legal systems such measures as are necessary to ensure judicial protection for workers whose employer, after the end of the employment relationship, refuses to provide references as a reaction to proceedings brought to enforce compliance with the principle of equal treatment. On this point, it should be noted that Article 6 of the directive requires member states to introduce into their national legal systems such measures as are necessary to enable all persons who consider themselves the victims of discrimination to pursue their claims by judicial process. It follows from that provision that the member states must take measures which are sufficiently effective to achieve the aim of the directive, and that they must ensure that the rights thus conferred can be effectively relied on before the national courts by the persons concerned. The requirements laid down by that article that recourse be available to the courts reflect a general principle of law which underlies the constitutional traditions common to the member states and which is enshrined in Article 6 of the Convention. By virtue of Article 6 of the directive, interpreted in the light of the general principle stated above, all persons have the right to obtain an effective remedy in a competent court against measures which they consider to interfere with the equal treatment for men and women laid down in the directive. It's for member states to ensure effective judicial control of compliance with the applicable provisions of community law. As the court has also held, Article 6 of the directive is an essential factor for attaining the fundamental objective of equal treatment for women and men, which is one of the fundamental human rights whose observance the court has a duty to ensure. And I just stress that point, the importance of having an effective system for ensuring that equality is maintained is here identified by the court as a factor enhancing the standard of effective judicial control, effective judicial protection.
But this rule barred all access to the court, didn't it?
No, my lord, it didn't.
Did it not?
Because, let's read on and we'll see.
Go on.
Well, let's read on and we'll see the analysis. It's not based on a bar of access. What it's based on is the chilling effect of the absence of this right of action on discrimination claims by employees. And we see this over the page. This is really important. Paragraph 24. The principle of effective judicial control would be deprived of an essential part of its effectiveness if the protection which it provides did not cover measures which, as in the main proceedings in this case, an employer might take as a reaction to legal proceedings brought by an employee with the aim of enforcing compliance with the principle of equal treatment. And this is the crucial passage. Fear of such measures where no legal remedy is available against them might deter workers who considered themselves the victims of discrimination from pursuing their claims by judicial process. This case is based on the concern that in the absence of this provision, workers may be deterred from pursuing their right to equal treatment in the employment tribunal. It's much more radical than anything that UNISON is asking the court to do in this case. In these circumstances, it's not possible to accept the UK's argument that measures taken by an employer do not fall within the scope of the directive if taken after the employment relationship ended. Then there's a reference to Article 7, which made reference to particular types of victimisation. And then, contrary to the government's submissions, having regard to the objective of the directive, which is to arrive at real equality of opportunity for men and women, and to the fundamental nature of the right of effective judicial protection, It is not, in the absence of a clear indication to the contrary, to be inferred from Article 7 that the legislature's intention to limit the protection of workers against retaliatory measures to cases of dismissal, which, although an exceptionally serious measure, is not the only measure which may effectively deter a worker from making use of the right to judicial protection. Now, I emphasise that case because it shows that, as a matter of European law, there is a positive obligation on the state to ensure an effective system of judicial protection for fundamental rights, including the right to equal treatment, and, of course, many other European employment rights, including working time directive and so on. And that means not deterring workers from obtaining access to employment tribunals. Again, wholly inconsistent with the approach of the Court of Appeal in this case. Now, the more recent case law that addresses the issue of access to justice, particularly in relation to court fees and analogous circumstances, relies on Article 47 and applies a proportionality analysis. Can I give you some references? I don't intend to turn these up, but just the key references. Firstly, Alassini, Volume 3, Tab 28, paragraphs 37, 47 and 61 to 65. And that was considering a system where there was mandatory ADR before a telecoms dispute could be resolved. That was held to be proportionate on an orthodox proportionality analysis. DEB, which is Volume 3, Tab 31, which was about a situation where legal aid and reimbursement of legal fees, court fees, was not available to a company as a legal person. And that's particularly paragraphs 27, 33, 35, 47, and 59 and 62. Again, proportionality test approached. And Star Storage, Volume 3, Tab 35, which was a requirement for an unsuccessful tenderer to provide a good conduct guarantee of 1% of the value of the contract if they wanted to challenge the competitive tender. Again, a proportionality analysis under Article 47, paragraphs 49 and 54 to 55. And that was held to be proportionate because it was a proportionate means of meeting the aims of deterring frivolous claims. The amount had to be refunded at the end. The amount was modest by comparison with the contract. The tenderers had to have sufficient resources in order to participate in the tender. And you can see that at paragraphs 56 to 61. Yes, it was refunded whether you were successful or not. So in summary, we say that there is no significant difference between the protection granted at common law under the Convention or under EU law, save possibly to the extent that EU law imposes a higher threshold, as we can see from the Coop case, a more demanding threshold for the government. The
Star Storage references,
yes.
Is that the Advocate General?
No, my Lord, that's the judgment.
That's the judgment.
Yes, the judgment itself refers to the Advocate General, paragraph 37, which is also worth reading. Now, the approach that the Court of Appeal took in this case, we say, is wrong in law. If we just turn up the judgment of the Court of Appeal, it's in the core bundle, page 273. And after considering various cases, paragraph 41, they say, although some help is to be got from the case law, it does not provide any clear criterion for identifying at what level a particular court fee becomes excessive or disproportionate. It's necessary to go back to the underlying principle. That is, that a claimant must not be denied access to court and thus access to justice, and that such access should be practical and not merely theoretical. In my view, it follows that the basic question is whether the fee payable is such that the claimant cannot realistically afford to pay it. That's entirely the wrong test. The question is whether there is a restriction on the right of access to justice, and if there is, then the restriction will be unlawful unless it is shown to be not an interference with the essence of the right and also shown to be a proportionate means of meeting a legitimate aim. And we've set out what we say is the correct test in our written case, paragraphs 59 to 62, which are pages 86 to 87 of the core bundle.
Thank you.
So now turning to the application of what we say is the correct test on the facts of this case. First, is there a restriction on the right of access to justice? Plainly and obviously there is. There is a financial barrier that is erected, and those who do not or cannot make the payment or are deterred from making the payment are entirely denied access to justice. And we see the outcome of that in the massive drop in the number of claims. What are the aims that are being pursued by the Lord Chancellor? There has been a little bit of inconsistency on that question, but the aims are now most authoritatively set out in the terms of reference for the review. If we go to part 5 of the appendix, page 1847, Annex A, it's 1593 of the internal numbering.
Thank you.
1593, my lord. So, terms of reference for the review: to review the impact of the introduction of fees in the employment tribunals and the EAT, including the scheme of fee remissions, to determine how successful this has been in achieving the original objectives. 1, financial, to transfer a proportion of the cost from the taxpayer to those who use the tribunal, where they can afford to do so. 2, behavioural, to encourage parties to seek alternative ways of resolving their disputes. 3, justice, to maintain access to justice. Now, we accept that those aims are legitimate. The court will note that one of the aims of this legislation is to maintain access to justice. That is significant because it means this is not a case where we're saying simply that you must balance the question of whether the aims are achieved against the importance of the maintenance of the right of access to justice. The government itself asserts that one of its aims is to maintain access to justice. If it has failed to achieve that aim, then the legislation is failing on its own terms.
It sounds very good, Miss Rose, but actually what they meant was maintain access to justice by discouraging weak claims.
Well, no, my lord.
Leaving the field clear for strong claims to be dealt with more expeditiously.
Lord, with respect, I don't think that's right. I think that that was what they meant under the second head. And your point about deterring weak claims was at some points in this litigation identified as a fourth aim, and sometimes as a mere hope. And the current position of the respondent on it is set out in their written case. It's Core Bundle 182. Paragraphs 1, 3, 4 to 5. And my Lord Wilson can see that they say in drafting this case, the Lord Chancellor has realised that there's been some inconsistency in respect of whether removing unmeritorious claims has been a freestanding objective of the policy or whether it might simply be a desirable outcome if it did eventuate. And then over the page, they say that they're conscious it's been put forward as a freestanding objective in the courts below. She apologises for the lack of clarity in this regard. Whether the discouraging of unmeritorious claims is an objective or a hoped-for byproduct, the Lord Chancellor's view is that there's been no significant change in success rates. So there's a concession that that aim hasn't been met, if it was an aim, but it appears to be entirely unclear that that is an aim. But that is not the aim that's being referred to when they say maintaining access to justice. They mean what they say. They mean maintaining access to justice.
Surely they mean maintaining appropriate access to justice, which may be circular, but the second one, behavioural, shows they can't mean that everybody is going to have access to justice who did before. The aim is to take people...
Well, everybody should have access to justice, but should be encouraged not to use it unless they need to.
Does it simply mean to ensure that there's not such discouragement to access to justice as to infringe the principle of access to justice?
That may be so, my lord. And it may be that the debate at this point becomes somewhat arid, but...
It may well be.
Moving on, the extent to which...
They clearly knew that they were going to discourage some people, didn't they?
Well...
Because there was a calculation on the basis there was going to be some fall.
At the time of the original impact assessment, they were entirely unclear. They said in the original impact assessment that they just didn't know what the elasticity of demand was. But so if we now come to the degree to which those aims are achieved, the first aim, financial, the court already has my submission about the relatively small financial contribution that is made and the error in the way the Secretary of State has addressed the achievement of this aim because of the erroneous assumption that the higher the fee, the greater the financial contribution. And we say that's fatal to the case of proportionality in relation to the main aim, which is the financial contribution. Now, the second aim, behavioural, to encourage parties to seek alternative resolutions, to encourage settlement, there's no evidence that that aim has been achieved to any degree, because as the court has seen, the rates of settlement have not improved. In fact, they have deteriorated. And in addition, as my Lord Wilson pointed out this morning, very shortly after the fees were introduced, compulsory early conciliation with ACAS was also introduced. So it is impossible to tell to what extent settlement rates would have improved with or without the fees. There's simply no evidence to show that this is more effective. And what the government says about this is at page 1804,
Money.
the behavioural objective. It's 1550, my lord.
Thank you. 1804.
1804, the external numbering, 1550 internal.
Yeah.
And they point out that there are more notifications than there were to ACAS in 2015-16 than there were claims in 2012-13. And they say more people are referring their disputes to ACAS under the early conciliation service than were previously using the voluntary service or the ETs. That's at 150. But of course, there's no way to tell whether that's because of the availability of the free early conciliation service or because of the fees. And at 152, they simply say it might indicate that the overall effect of the government's reforms to the system has been to help more people to seek resolution for their disputes. Well, no doubt. Introducing mandatory early conciliation has induced more people to go to ACAS, but there's no evidence at all that the fees have had any impact on that at all. And they don't even suggest it. At 153, they fudge the point by saying the combined effect of fees with the mandatory requirement to consider ACAS has been successful in encouraging people to use ADR. So we say there's no evidence that that aim has been met to any degree at all. Then access to justice. In our submission, it is clear that access to justice is not being maintained for the two reasons that I've already given. First, in relation to the affordability of the fees and the inadequacies in the remission schemes. And secondly, because of the problem of the lack of proportionality between the fee and many typical employment tribunal claims. And the Lord Chancellor's response to this, we go to the written case. It's page 189.
Yep.
Paragraph 156. It said, the Lord Chancellor understands the logic of paragraph 104 of UNISON's case, namely, that for those to whom the value of the claim is close to or even exceeded by the fee may decide not to litigate. However, in her submission, this would not mean that they've been denied their fundamental right of access to the court. Well, In our submission, that's wholly inadequate as a response to the problem that the fee is set at an inherently disproportionate level that makes it irrational for an individual to pursue their rights. So overall, if you look at the three aims that are maintained, access to justice, we say the scheme is actively counterproductive. There's no evidence at all in relation to the fees enhancing settlement. And in relation to the financial contribution, the Secretary of State's not in a position to demonstrate that a lower fee wouldn't have raised more money. Now, then the question of less onerous alternatives, it is obvious that there are many less onerous options that could be taken here, including fees that are more closely tailored to particular values of claims, as we see in the county court. And then finally and fundamentally, the question of fair balance. Because there is clearly a very serious impact on the right of access to justice in this case, and in particular on the right of access to justice of those who are seeking to invoke claims that are themselves involving fundamental rights protected at European law, in the only forum where those claims can be enforced. And this scheme is shutting out, in effect, large numbers, very large numbers, of the very types of small claims that the Employment Tribunal was set up to hear. In Hillingdon terms, claims that objectively should be brought are not being brought. There is, underlying this whole problem, one final, further, very important error of principle, which underlies the whole of the Lord Chancellor's case. And it is this: from the outset and at all times, there has been a complete failure by the Lord Chancellor to place any value at all on the social benefit of the enforcement of legal rights. The benefit that we saw the ECJ describe in the Coote case, the benefit of ensuring equality, and we would say the same applies to other types of employment rights. Now, the social benefits we say are obvious. They include financial benefits for society as a whole. If pregnant women are able to enforce their rights to paid antenatal care, their health will be better, the health of their babies will be better. That is good for society as a whole. Similarly, if employees are able to enforce claims for unfair dismissal and discrimination, then good employers don't face unfair competition from bad employers who might otherwise seek to exploit their workforce unlawfully without fear of being held to account. One of the classic points that one sees in European cases, you have to have proper enforcement economically to ensure that there's a level playing field between those who comply with the law and those who seek to evade it. Other rights have obvious direct financial implications. Employees who are unfairly dismissed may be removed from the labour market, not able to contribute their talents to society. Those who are overworked in a breach of the Working Time Directive may suffer health problems. Harassment, again, has obvious implications for the lack of talent, and so does discrimination. The absence of women in senior positions, in many cases, is a result of systemic discrimination. Now, in that situation, one would have expected some value to be attributed by the Secretary of State to the maintenance of the effective enforcement of employment rights. But in fact, explicitly, a value of 0 was attributed. And I want to just show this to the court.
Okay.
It's part 3 of the appendix.
Thank you.
It's the full impact assessment.
Yes. You referred to
It's
it.
page 934 of the external numbering, 680 internally.
Thank you.
This is the impact assessment that accompanied the regulations.
Yep.
This is from 2012. It's before the regulations, but it's the full impact assessment. And what you can see in this summary at page 934 is a summary of the key costs and benefits.
Right.
And first of all, costs. And you see costs, the fees are set out, and losses to lawyers who might lose fees from claims not being brought. But then other key non-monetized costs by main affected groups, not applicable. So no non-monetized costs. And then when we see the benefits of the policy, we see amongst the benefits that employees who choose not to bring an ET claim when they would have done in the base case, avoid the costs from making a claim, which is quite a remarkable way of approaching it. Now then, if we go into the full text of the impact assessment, go to page 946, paragraph 3.1. This is 692 internally.
Thank you.
This impact assessment identifies both monetized and non-monetized impacts on individuals, groups and businesses, with the aim of understanding what the overall impact to society might be from implementing these options.
Sorry, which paragraph are you reading?
3.1, my lord.
Beg your pardon, thank you, got it, yep, thank you.
The costs and benefits of each option are compared to the do-nothing option. Impact assessments place a strong emphasis on valuing the costs and benefits in monetary terms. However, there are important aspects that cannot readily be monetized. These might include how the proposal impacts differently on particular groups of society, or changes in equity and fairness, either positive or negative. So they recognize it as a possible heading. But then when we come to the relevant place, it's at page 970, 716 internally. You see the heading wider benefits just above paragraph 4.88.
Yep.
And this is talking about benefits of the policy. They say the ET and EAT are completely subsidised by the taxpayer. Their services are provided free of charge to users, which means consumption is higher than would be the case under full cost recovery. Economic theory holds that in a conventional market, this higher level of consumption results in a technical deadweight loss to society, as the additional gain to consumers and producers is outweighed by the additional cost to the taxpayer. And then there is a footnote. This assumes that there are no positive externalities from consumption. In other words, ET and EAT use does not lead to gains to society that exceed the sum of the gains to consumers and producers of these services. That's the assumption of the impact assessment, that there are no social gains to society from the use of the employment tribunal, that the effective enforcement of employment rights has a nil social benefit.
Well, it says does not lead to gains to society that exceed.
Yes.
So that implies a balancing, does it not?
Now, my lord, what they're talking here about positive externalities, because the concept of an externality in economics is that generally when people make decisions about their actions, they only take into account the costs and benefits to themselves. So somebody bringing a claim in an employment tribunal doesn't consider whether their enforcement of their employment rights will keep the employer on the straight and narrow and have wider social benefits. They only consider whether it's worth their own while doing it. Yep. But in a situation where you conclude that, in fact, it's good for society for employment rights to be enforced so that employers are kept on the straight and narrow, then that is a positive externality. But the assumption here is that there's no positive externality. Now, we say that is obviously fallacious. It's contrary to the express authority of this ECJ and Coote. And we say, again, it vitiates this whole policy right from the beginning, because they haven't done a proper cost-benefit analysis. They've concluded that for a net benefit of around 6 million a year, it's worthwhile sacrificing nearly 70% of all employment tribunal claims. And the reason they've concluded that is because they don't attribute any social value to those claims.
That's a point which is made in the article by Adams and
It is. Your Lordship's right. And can I just give you the reference, because I'm almost out of time? It's volume 13, tab 177, and it's in particular pages 6641 to 3, and there is a very useful analysis in that article.
Just give me those page numbers again, please.
It's volume 13, tab 177, page 6641 to 3.
Thank you.
What's the reference in your case, Miss Rose?
My Lord, it's not referred to in our case.
You cited the footnote there as well.
Yeah, they cite the footnote.
They do cite the footnote.
160,
But we say this point is particularly significant now, because when the impact assessment was produced, the government didn't realise how big the drop was going to be in the number of claims. But now in the review, they're fully aware of the impact in terms of the catastrophic fall in the number of claims that are being enforced. And in that situation, we say it was incumbent on them to at least consider this point and not to give it a value of nil.
We must be careful not to mix apple and pears in one sense. This footnote is an apple in the sense that it was something that's always been there.
Yes.
What you call the catastrophic fall-off.
Yes.
Subsequent.
That's right. But after the catastrophic fall-off, there's no revisiting of the footnote.
Right.
The assumption is maintained.
The footnote assumption is a false assumption anyway, you say.
Well, yes, it is, my Lord.
Its falsity is in no way affected by the...
I agree, my Lord. I agree, my Lord. I agree. But we say that the severity of the impact makes the error the more serious. If it had turned out that there was no significant drop in claims, it wouldn't matter. But given how big the drop in claims is, this is an urgent burning point which ought to have been addressed.
The role of the law in setting standards for general social behaviour is something that's been quite extensively emphasised, in particular by the Council of Europe.
Indeed, my Lord. Yeah. Indeed, my Lord. Yes, and in EU law, of course, and the Coote case is an example of that. Now, I'm almost out of time. I want very briefly to deal with a couple of points before I sit down. First of all, flaws in the Court of Appeal's approach. Paragraph 45, in particular. This is page 274.
Yeah. Paragraph 45.
Yes. Paragraph 45, the court essentially rejected the relevance of the whole disproportionality argument.
Understand.
And at the end of it, they say, the essential question is whether the claimant can in practice pay the fee, not whether it be a sensible use of his or her money to do so, which would depend on many imponderables, including whether claims being pursued with objectives not proved pecuniary. If the effect of the fee regime is to make potential claimants think twice about starting proceedings for small sums, that is not axiomatically a bad thing. We say that's totally the wrong approach, given the nature of this scheme and its statutory purpose.
Right.
Now, my Lord, then reliance on Regulation 16, that's the exceptional cases formula. Your Lordships already have the point that the number of claims granted under the exceptional cases scheme are very, very small.
Yeah, we have that. We have the figures.
And that it can't meet the disproportionality point at all.
Understand.
Then the point, the significance of the fact that this is a systemic challenge, we say that the right test is the test that was applied by the Court of Appeal in detention action. That's Authorities Volume 1. Sorry, I don't have the tab number. You will give it to me. The test that's applied is at 25 to 27. And the question is the restriction on access to justice systemic? Is it inherent in the scheme? Now, there is an alternative test, and I just want to flag this. In particular, in your Ladyship's judgment in the Christian Institute case, Volume 5, tab 65, it's tab 11, detention action is tab 11. The Christian Institute case at Volume 5, tab 65, which was a challenge to a Scottish scheme allocating named persons to children who could share information about them, which was said to be potentially a breach of Article 8 in individual cases. And at paragraphs 87 to 88, Lady Hale, looking at two earlier cases, BB and MM, so the question
was by myself, was I?
I'm not suggesting you were, my lady, but I'm simply picking it up from your speech. But the point there...
It was a joint judgment.
Oh, I beg your pardon. I beg your pardon. A joint judgment. But the solution in that case was to have proper guidance about the practice in individual cases, and that's at paragraph 101.
Where's this?
Sorry, it's Volume 5, tab 65.
Thank you. Paragraph.
The test is at 87 to 88.
Thank you.
It's the guidance point, is it, when you're talking about defects in the system.
Yes, and it's what it's talking about is cases where you have an overall system, but individual cases, there may be a risk of disproportionate decision-making without appropriate guidance. We say that's got nothing to do with this case. Well, what you have is a fixed system of rules about what the fees are and the circumstances in which you can get remission, subject only to the Regulation 16 exception.
Thank you.
Now, ground 2 is fully developed in our written case.
Sorry, what was your point on what Lady Hale said? I must have missed.
Yes, my point, my Lord, was that it's dealing with cases where you have a risk of disproportionate decision-making in individual cases, unless there's proper guidance. And we say that's different from this case. The right test to apply in this case is the detention action test. Yeah. Now, ground 2 is fully developed in our written case and is obviously very closely allied to ground 1. But the rights that we are there relying on are the rights established by Parliament in primary legislation. And the test, we say, is derived from the JCWI test. That's at Volume 1, Tab 10, and it's Lord Justice Simon Brown, as he then was, particularly at pages 2329 to 2322. And our point is simply that this scheme frustrates the intention of Parliament in establishing the employment tribunal system, particularly for the hearing of modest claims brought by employees against their employers because of the way the fees are structured, which makes such claims now futile.
So it's the same...
The same point, same factual case.
Do you say you can succeed on that,
yes,
but not on ground 1?
My Lord, we say conceivably we could, yes.
Conceivably?
Yes.
Okay.
But we say, obviously, that we win on both. For preference. My Lord, I apologise for trying your patience. And
you haven't done.
Those are my submissions, and you will hear from Ms Monaghan first thing tomorrow morning.
Thank you very much indeed, Ms Grace. You've got through a lot of material very efficiently. Thank you. We'll resume again then at 10:30 tomorrow when we look forward to hearing from Ms Monaghan. Thank you very much. Court is now adjourned.